honor and privilege to welcome you all to this distinguished lecture on Articles 226 and 227, Scope of Writ Jurisdiction and Supervisory Powers of High Court. The subject before us today is one of the most vital aspects of constitutional law. Articles 226 and 227 both empower our High Courts to issue writs not only for the enforcement of fundamental rights, but also for any other purpose. This right jurisdiction has made the High Courts guardians of justice, guarding individual liberties, ensuring accountability, and filling gaps when no other remedy may be available. Article 227 complements this by giving the High Court supervisory authority, enabling them to keep subordinate courts and tribunals within the bounds of law and procedure. Together, these provisions remind us of the central role of the High Courts in preserving rule of law. To guide us through this fascinating and complex subject, we are deeply privileged to have with us Shri Asim Pandya, Senior Advocate, High Court of Gujarat. Mr. Pandya is one of the most respected voices in Gujarat High Court. With over 3 decades of practice, he has appeared in significant constitutional and administrative law cases under Article 226 and 227, shaping the discourse on judicial review and supervisory powers. He has also served as the President of Gujarat High Court Advocates Association, where he has played an active role in the bar administration and professional representation. Beyond the courtroom, he has authored works on constitutional remedies, bail and criminal procedure, contributing richly to legal scholarship. He has also delivered expert lectures across institutions, making complex constitutional questions accessible to students and practitioners alike. His engagement with both practice and academia makes him uniquely suited to speak on today's theme. I now request Professor Dr. Giri Shah, Head of Academic Affairs, and the Center Faculty Head of GNLU Centre for Constitutional and Administrative Law, to kindly facilitate Shri Asim Pandya with a copy of Constitution of India to set the tone for today's lecture. It is my honor to further invite Giri sir to deliver the welcome address to further set note for today's lecture.
Respected Chief Guest for today's lecture, Senior Advocate Asim Pandya, and dear students of Gujarat National University. It's a great moment for me because I think I, as a faculty of constitutional law and administrative law, learned a lot from his book. That's what has been. Sir has published a book that is Writs and Other Constitutional Remedies. I think our library have plenty of copies. Many of you maybe might have seen this book and used. Many of our students have used this particular book for many moot court competitions and other projects. And I used to keep a copy of this book in my office, and I am very much fascinated about your writing and academic contribution to the students and the teachers. Sir, our Center for Constitutional and Administrative Law in the last 1 year is actively involved in developing various programs in relation to constitutional law and administrative law. During last semester, in fact, we had the former Supreme Court Judge Justice OK coming to GNLU and addressing the students, and we even conducted one-day training program for Gujarat Vigilance Commission, and we every day conduct lectures and programs in relation to Constitution Day, and this year we are planning with a essay competition during November 26 on the theme of electoral reforms, and also we are planning lectures during the Constitution Day celebration. Sir, it's great to have you along with our students here to discuss on this particular pertinent topic. On behalf of Gujarat National University, I extend a warm welcome to you, and once again, on behalf of Gujarat National University, I thank you for coming to GNLU and to be part of this particular program. And You have to remember that sir is the member of GNLU General Council, the apex body of Gujarat National University. So sir is already part of Gujarat National University. So on behalf of all of you, I extend a warm welcome.
Yes, sir. It's going to be an interactive session. Yes, sir. So it's better that I will be there among them. I have therefore not formally attired myself with the blazer and all those things. I said it will be like it's a call here. Is it needed? I am audible, I think. Yes, yes, sir. I don't think so. It is needed. Yes. So today, it being an interactive session, I would request one of you to begin the discussion so that it becomes very fruitful. Otherwise, it would be a unilateral dialogue. I will keep on saying something and you will keep on listening to me. Rather than, since it's an interactive session, I would request one of you to open this discussion with anything. So we can start with that. If anyone is willing to open up the discussion. Yes, please.
Since this is the Center for Constitutional and Administrative Law and the Constitution is the grand norm on which our whole legal system works, it is very important to understand the very functionings on how the Constitution works, especially for us law students to understand the intricacies of this beautiful document that has been drafted and given to us by our forefathers, especially the present topic of Article 226 and 227 having such wide jurisdictions. It helps us understand that there are various ways and avenues through which we can protect the legal and constitutional rights of our fellow countrymen.
Right.
So it becomes a very pertinent session, and thank you, sir, for coming here.
Thank you. So now let me begin so that discussion can start. How do you describe this article? What is the nature of jurisdiction? Whether it's a original jurisdiction, whether it is supervisory jurisdiction, whether it's an appellate jurisdiction. What is the nature of this jurisdiction? It is, somebody is saying original jurisdiction, one person said that it is supervisory jurisdiction. So the first question which should arise is that what is the nature of this jurisdiction? Because many things turns on the nature of the jurisdiction. So if I am to describe this jurisdiction, I would say that it is a special jurisdiction, special kind of original jurisdiction. Otherwise, somebody said that it is extraordinary jurisdiction. Now, extraordinary jurisdiction has been understood in a different context under the letters pattern, because when we talk about the High Court and its jurisdiction or powers, we must have at least some historical background of the High Court, establishment of High Court, what was the historical background, how High Courts came to be established, what were their powers prior to 1947, before the Constitution, when 1950 it was brought into force. So prior to independence, how High Courts were established, what was the law which established the High Court, even prior to the establishment of High Court, whether there was such a court which used to issue prerogative writs or not. So that little bit historical background is relevant to understand the width of the current Article 226. For understanding the historical background, one may have to go to the Regulating Act 1773. That was the first enactment which was enacted by British government to establish Supreme Court of Judicature at Fort William in Bengal and Bombay and Madras. So that was the first act, that is 1773 Regulating Act, which empowered the British government to issue charter to establish Supreme Court of Judicature in pre-presidency terms. So that is how our history began. That with the earlier there were Sadar Diwali Court, Sadar Faujdari Court, Mayor Court, etc., etc. But they did not possess the extensive jurisdiction which was for the first time being conferred upon the Supreme Court of Judicature at Court William. First was this court at Calcutta, which was established by a letters patent of 1770. So that is how the system of superior court established in India by the British government. Now, what is the relevance of this charter, which established Supreme Court of Judicature at Calcutta on 26th March 1774? Clause 5 of this charter or letters patent equated the jurisdiction of this court to the jurisdiction of King's Bench in England. So we come across frequently the word writ, word prerogative writs. So those prerogative writs were used in England by King's Bench and Chancery Division. So these 5 prerogative writs that are known as writ of habeas corpus, writ of certiorari, writ of mandamus, writ of prohibition, writ of quo warranto, etc. So these were known as prerogative writs. So King's Bench in England possessed such jurisdiction. But when it came to establishment of courts in India, this charter for the first time said that we established these courts in India, first in Calcutta, second in Madras, and third one is in Bombay. And these courts were given various kind of jurisdiction, ecclesiastical jurisdiction, then later of administration, testamentary jurisdiction, jurisdiction pertaining to divorce proceedings. So many kind of jurisdictions were conferred on these courts. But most important aspect for our purpose for today's discussion is that these 3 courts, which were established by 3 charters, one is of 1774, another is of 1800 and 1823. So Calcutta High Court by 1774 charter, Madras High Court in 1800, and Bombay High Court, Bombay Supreme Court in 1823 mostly. So these 3 courts were equated with the jurisdiction to issue prerogative writ. So that is how in India the writ jurisdiction was for the first time introduced. So apart from original jurisdiction, this kind of special jurisdiction was conferred on these courts. These courts functioned up to 1861 as Supreme Court of Judicature. But after 1858 rebellion, British government took over the rule over India, and it established its rule, and they abolished these 3 Supreme Courts. And by 1861 Indian High Court Act, these Supreme Courts came to be abolished, and these 3 presidency towns were given High Courts, High Court of Judicature at Fort William at Bengal, Bombay and Madras. Now interestingly, if you try to find history, that how did this writ jurisdiction came in India, you will not able to find unless you go back to 1774. So Indian High Courts of Act also, you will not find that our High Courts, how come they possess this kind of jurisdiction. So 1861, they were converted into High Courts, and by letters patent, new letters patents came to be issued, where clause 8 abolished, Indian High Courts Act section 8, 9 and 10 are relevant for our purposes. So section 8, 9 and 10 by which Supreme Court is abolished in the place of Supreme Courts, the High Courts came to be established, and whatever jurisdiction that was possessed by these 3 chartered courts, Supreme Court, is continued with these courts. So that is how this writ jurisdiction became part of our country by establishment of these 3 chartered High Courts. Now interestingly, you must remember that barring these 3 courts, High Courts, that is Bombay High Court, Madras High Court and Calcutta High Court, no other courts which were established later on possess this kind of special jurisdiction to issue writs, additional writs. So please remember this, because sometimes academically this issue might be required to be understood. When in the context of when case arises in future, many a time we have to go back to the historical aspect, and we have to go to the origin, that how these powers are originated, and whether all the courts that were established during British rule in many states, Allahabad High Court, then Pepsu High Court, means Patiala and East State Punjab Union, that kind of Pepsu Court. So many courts were established, High Court, but all the High Courts did not possess this deep jurisdiction. So you must remember this. So with this, now sometimes a question arises whether this Article 226, coming back to, because it was a limited, I must also point out that the jurisdiction which was conferred on this Calcutta High Court, Bombay High Court and Madras High Court was continuation of Supreme Court. Now Supreme Court had very limited jurisdiction. It could examine the dispute between the British subjects only. That was the first requirement. Second is the persons who are employed in East India Company. So if there is a dispute between such persons, then it would have a jurisdiction. Then it has jurisdiction over mayors and aldermen also. So any dispute or any staff which is appointed by mayors and aldermen. So this court had very only with regard to the Indian subjects. If the party by agreement conferred the jurisdiction on this court, and if the value of the suit is above ₹500, then only the Supreme Court of Judicature would have a jurisdiction. So it had a limited jurisdiction, and the jurisdiction did not extend beyond the presidency term. So that is very important to know, because when now I am coming to the current 226 very soon. So please keep it in mind that the original 3 high courts did possess traditional writ jurisdiction, but it was much circumscribed. It was not that expansive, which was available in in England. So first of all, this only limited to British subjects, mayor, aldermen, people employed in East India Company, and when the Indian subjects by agreement confers the jurisdiction, and when the value of the proceedings is above 500, then only this court would have jurisdiction. So a question is this, that whether the current Article 226, whether Indian courts, Indian high courts possess similar jurisdiction prior to independence or not. That would be the first question which we'll put for discussion. Now what is your answer from the discussion? What is your answer whether Indian high courts all over India, whatever high courts came to be established, whether they possess similar jurisdiction that is conferred by Article 226 prior to 1950? What is your answer? The answer is partly yes, so far as 3 chartered high courts are concerned, because it was very limited jurisdiction of issuing traditional writs. So for chartered high courts, they stand on a different footing, and other high courts which came to be established by subsequent letters patent stood in a different footing, because they did not possess this traditional jurisdiction. And most important aspect which people do not know is that though they were considered to be prerogative writs in England, in India, so far as habeas corpus is concerned, it became a statutory writ. There was an amendment in Criminal Procedure Code 1898, where section 491 provided for issuance of writ of habeas corpus, which conferred power of issuance of writ of habeas corpus in all high courts, not confined to 3 courts. So far as writ of habeas corpus is concerned, it became statutory. So it ceased to be a prerogative writ in India much prior to independence. So it became statutory writ. Similarly, writ of mandamus, we will discuss some portion of writ of mandamus certiorari very quickly. But this historical background will give you insight as to how this jurisdiction has been evolved and how it has been conceived by our constitutional framers while enacting Article 226. So far as writ of mandamus is concerned, it also becomes statutory. Section 45 to Section 50 of the Specific Relief Act, earlier Specific Relief Act, provided for issuance of writ of mandamus. So it also ceased to be a prerogative writ in India by virtue of the statutory provision. So only 3 writs remained to be a traditional conventional writ, that is habeas corpus, prohibition, certiorari and quo warranto. 4. 2 things became statutory. Now when constitutional framers set to frame the constitution, they had many things in their mind, that in our constitution we are conferring fundamental rights to the people of India. I would not say conferment because it is a recognition. They are inbuilt, inherent human rights. They are being simply recognized by the Constitution of India. So, Part 3 of the Constitution of India, they are recognizing these fundamental rights. Some rights are available to citizens, some rights are available to any person. So in different setup, when they thought that how to implement or how to enforce these fundamental rights. So first they had in their mind that our highest court, that is Supreme Court of India, must be equipped to render quick and inexpensive justice to citizen whenever there is violation of a fundamental right. So it was original draft article was 25, which became Article 32. So whereby our constitutional framers said that whenever there is an infringement of a fundamental right of any person in India, that person will have a right to approach the highest court as a matter of right. So Article 32 said that right to approach Supreme Court is guaranteed. So it's a fundamental right itself under Article 32. So first they thought that we should equip the highest court to see that no person in India suffers at the hands of the sovereign, maybe executive, maybe parliament or judiciary. So a person should not suffer in the hands of any of these 3 organs of the government. So that is how Article 32, and it has been said that it is heart and soul. Mr. Ambedkar said that if he were to name any particular article in the constitution without which the constitution would be nullity, he said that it is the Article 32, which, because EB just UB remedium, so without remedy, right is meaningless. So it is very heart and soul of the Constitution of India. So that is how then they thought that we should give Supreme Court of India power to do justice whenever violation of fundamental right is there. Then they also thought that there were high courts. So why not confer them similar power? But the power is much more expansive than the power of the Supreme Court. Supreme Court, you please mark it, that Supreme Court has jurisdiction to issue any direction, order or writ, including writ in the nature of habeas corpus, mandamus, so and so, for the enforcement of fundamental right. So where Article 32 is very clear that only for the enforcement of fundamental right to access, Supreme Court has been guaranteed. So it is very limited. But then our framers were quite conscious of the fact that injustices with regard to fundamental right, but for other aspects also, there might be instances where a citizen or a person might suffer injustice, and therefore there should be a remedy provided at the state level also. So they enacted Article 226, and we will have to discuss in 4 segments this Article 226. It's every segment is very important. The provisions of Article 32 starts with non-obstant clause, that notwithstanding anything in Article 32, every high court shall have power throughout the territory in respect of which it exercises jurisdiction to issue to any person, please underline any person, word any person is first, or authority, and in appropriate case any government. So there is a myth that whether writ would go to or direction can be issued under Article 226 to any person or private person or not. So that we will discuss a little later. But if we go by the plain language, we will have to focus on plain language. And the width of the Article 226 should not be restricted by interpretation. So it says that any person or authority and in appropriate case any government. Then what is the power? To issue direction or order or writs, including. So word is including and the word in the nature of. In the nature of is also important. So first segment is that any person, authority and in appropriate case any government. That is first segment to be discussed. Second is direction, order, writs, including writs in the nature of habeas corpus. So word in the nature of has also some significance in the history. So in the nature of habeas corpus, mandamus, certiorari, quo warranto. And then next word is or any of them. So it can be singly, you can ask for a direction, you can combine it with any other writ. So writ of habeas corpus and writ of mandamus can also be combined. You can simply seek direction also, you can seek also any order in combination and in isolation also. So any of them for the purposes of enforcement of fundamental right or rights guaranteed in Part 3 or for any other purpose. So though article is, you think that it is very simple to understand, but when it comes to practical implementation or interpretation of this article is concerned, there are large number of misgivings and misconceptions. Throughout, even Supreme Court is still confused with this jurisdiction because whenever they have rendered certain judgments, they have not gone back to the historical aspects and they have just discussed certain aspects and then laid down a law. But being an author, it is our job to go to the root and we will have to find out whether the judgment of the Supreme Court in a particular case is correct or not. So now coming with the first segment, that direction, order or writ can go to any person or authority and in appropriate case any government. Now somehow from the beginning all lawyers have been trained to make a statement in his writ petition that respondent is a state within the meaning of Article 12. Now where is the need of making this statement? Only when you are claiming fundamental right. The statement is necessary because the fundamental rights are available usually against state or instrumentality of state that are defined under Article 12. But if you go by the language, it is not necessary. In a given case, if a private individual violates fundamental right, you are entitled to approach the High Court. But the judgments of the Supreme Court has confused all these things. But fortunately, recently in Kaushal Kishore case, which you might be aware of it, where question number 2 and 3 was specific this question, whether a petition can be maintained against non-state actors and whether fundamental rights can be claimed against private citizen, and if there is a violation by private citizen, whether person has to take recourse of ordinary civil remedy or they are entitled to approach the High Court by way of petition under Article 226. And the Honorable Supreme Court has clearly held that if a person who is violating the fundamental right is a private person, then if certain conditions are satisfied, a petition under Article 226 would be maintainable. Now, For doing that, the Supreme Court has considered all these fundamental rights, which you will find in a table of my book also. I made that table in 2009. Similar table has been reproduced by the Supreme Court in Kaushal Kishore's case, that certain fundamental rights are available against private persons also. It is not necessary that every fundamental right is available against state or instrumentality of state. You will have to see each and every fundamental right. Like Article 14, then it is clearly stated that state shall not treat somebody unequally and there shall be equal protection of law. So state word is there. So clearly for violation of Article 14, usually the respondent should be state or instrumentality of state. But if you examine Article 15 sub-article 2, which says that in respect of any hotel, restaurant, wedding garden, roads, theatres, etc., no person shall be discriminated on the ground of race, religion, caste, etc., etc. Now where is the question? It is clearly available against a private person. Suppose if I go to any theatre and the theatre owner refuses that I will not admit you to the theatre because you have a grey hair. So there is a discrimination. Whether in such a case I am supposed to go to ordinary civil court or I am supposed to invoke the High Court's jurisdiction under 226. The answer is emphatic yes. I am entitled to enforce this right against, because once restaurant is thrown open for public usage, when roads are dedicated for public use, every person will have a right to access that, and that is guaranteed under Article 15 sub Article 2. So if in case of violation thereof, if I am to take recourse of that dilatory remedy of civil suit, then it will not serve the purpose. I need immediate relief. So I will have to approach the High Court for enforcement of. So all these aspects have been clarified in Kaushal Kishore's case. So one must read their judgment to at least relieve yourself from the misconception that petitions are maintainable only against state or instrumentality of state. So I will not discuss much on it because time is short. So we will just broadly discuss other aspects and then we'll again start discussion. But I think if somebody has question in the midst also, he can raise hand and I will be very happy to answer. So please keep it in mind. Then there is another judgment, Shakti Vahini's judgment versus Union of India, where honor killing, concept of honor killing was deprecated, and the justice administered by half panchayats, that has been deprecated, and it has been said that such a usurpation of the power is absolutely impermissible, and it was declared that no such authorities can exist in half panchayat, and any decisions taken by such panchayat would be violative of fundamental rights. So it is not that even half panchayats were directed that no such half panchayat should be there. So there are instances and instances. As I said, 15.2, then a person below 14 years cannot be employed in a dangerous manufacturing process or industry. So here also this fundamental right is available against private individual, because factories, it is a prohibition against employment of a person below 14 years. Suppose factory indulges into it, then can we not approach the court and say that prohibit him from employing such person? So a petition would be, so it depends, yes. No, therefore the constitution envisages that a person below 14 years should not be engaged in an industry which is harmful to the health of, and child needs support of the mother and family. Of course, the family needs might be different, but there is a constitutional prohibition, so we cannot go to the wisdom of the constitutional framers. And it has to be, suppose even if you question that wisdom, then it can be examined on the basic structure doctrine only, because fundamental rights can be now taken away. It It is not necessary. Fundamental rights can be taken away by the constitutional amendment also, after Keshwanand Bharti. Only restriction is that any constitutional amendment cannot violate the basic structures of doctrine. So I was just trying to give illustration that these are the fundamental rights, like Article 21. It also says that no person shall be deprived of his life or liberty except the procedure established by law. Now it has been interpreted in a manner whereby private industries polluting the environment are saddled with the fine and the remedial measures. So sustainable development, then compensating the damage which has been caused to the environment by private industries, and fine. So all these things in absence of even environmental law. Because if you take Environment Protection Act 1986, so prior to 1986 there was no law. Of course, some laws may be there, Water Pollution Act or maybe, but Environment Protection Act was enacted in 1986. So can you say that before that you did not have fundamental right of clean air, clean environment or not? So if you possess, obviously the Article 21 has been interpreted in such a way that it has, every citizen has a right of fresh and free pollution-free air or pollution-free environment. So in such cases, so it depends on the nature of the fundamental right which you are invoking, and depending whether it is available against person, it is available to a person, to a citizen, it is available against state or any person. So we will have to make out a case for entertaining a petition in Article 226. Now going by the nature, at the beginning we said that it is a special jurisdiction, special jurisdiction of very summary nature. Because suits are always available. For any civil wrong, the civil suits are maintainable. If somebody has done tort to you, you are entitled to claim damages. If somebody has broken promise, you are entitled to file suit for breach of contract, compensation, specific performance, etc. For criminal wrongs, there is a provision IPC now, BNS and BNSS. So there is a provision that this can be compensated by this kind of court, that's ordinary civil courts and ordinary criminal court. But then the constitutional framework says that there are certain instances where injustice is required to be prevented immediately. In such a case, if a person is asked to avail of ordinary remedies, then it will not serve the purpose. Therefore, the Article 226 has been enacted in such a way that in such a case, the party can at least have a recourse of Article 226. So, on the first aspect, that it can be usually state or instrumentality of state, but it is not that it can be issued only to state or instrumentality of state, it can be issued to private person also. One interesting instance, very curious thing, that in state of Bihar versus BCCI, Board of Cricket Control of India, the issue arose that whether it is a state within the meaning of Article 12 or not. The Supreme Court said no, it is not a state, but still it discharges public functions. So arranging cricket matches, having all stadiums and all those things, selection process, so everything is in the nature of public duty, and therefore though it is not a state, it is still amenable to jurisdiction under Article 226, and Supreme Court issued direction from time to time to bring reforms in every cricket association, including BCCI, that one person should have a cooling off period after electing twice, etc. So there are several restrictions imposed by way of that judgment. So that aspect is very clear. Now coming to the second aspect, that directions, orders, writs, including writs in the nature of. Now first I will point out that why word in the nature of has been used. There is a historical significance. In England, by Miscellaneous Justice, Administration of Justice Act 1938, the word writ was removed as a prefix of all writs, barring habeas corpus. So in England in 1938 onwards, they became order in the nature of mandamus, order in the nature of certiorari, order in the nature of quo warranto, order in the nature of prohibition. Only writ of habeas corpus was not disturbed because it had a historical background with the Magna Carta. So civil liberty, personal liberty was considered to be so sacrosanct. So they thought that we do not want to disturb this writ word as a prefix of the habeas corpus. But so far as other writs are concerned, they become order in the nature of. So when constitution was framed, obviously the constitutional framers were aware of it. So consciously it is, otherwise they would have retained the only words, writs. Why should they incorporate word in the nature of? So because of the change that had taken place in England in 1938 by this Administration of Justice Miscellaneous Provisions Act 1938, these all writs, the word writ has been omitted and it has become this. Now there is an interesting instance of issuance of order in the nature of quo warranto in India also. Because in 1945 in Hamid Hassan versus Banwari Lal's case, that is reported in AIR 1945, Privy Council page 90. So it was a case where a person wanted a writ of quo warranto to be issued. So there it is clearly stated that the court would be issuing order in the nature of quo warranto. So there, before constitution came into force, there this kind of development had already taken place in England, and it had found judicial recognition in the judgment of Hamid Hassan versus Banwari Lal Roy. Of course, writ was probably not issued because the person concerned who is alleged to have usurped the public office was possibly situated outside the Calcutta town, and this court had limited jurisdiction. So writ was possibly denied. I am not sure, but you may examine. But the question arose whether order in the nature of quo warranto should be issued or not. So having this background, they thought that we should not confine the jurisdiction of the High Court to issue only traditional writs. So they incorporated word in the nature of. So it is not necessary strictly to go by the technicalities associated with all traditional writs, because all traditional writs have many technical problems. So unless those conditions are fulfilled, person would not be entitled to avail of those remedies. So to obviate this aspect in the nature of word has been used, and to see that in a vast country like India, the jurisdiction of High Court should not be fettered to issue only these traditional writs because it had a very limited scope. Suppose mandamus can be issued when a public duty is conferred and public duty is not being performed by the authority or a particular officer, or somebody is acting contrary to the statutory mandate, then to forbear that person from acting contrary to the statutory provision, writ of mandamus would lie. So there has to be demand, there has to be refusal, then only mandamus would be issued. So in a vast country, the constitutional framers thought that we would not like to confine the jurisdiction of High Court to only traditional writ. We should empower the High Courts with much wider power. Much wider power. Therefore, they said that High Court shall have power to issue direction. So direction is not prefixed by or circumscribed by any other word. So direction, any kind of, which meets the ends of justice. It is not necessary that traditional writ has to be prayed for. So direction, word, orders, and writs. So writ is used as third. So these are merely tools to achieve the goal. So here, unfortunately, in our constitutional jurisprudence, more importance is given to the tools, which is absolutely uncalled for. Tools are to be used to achieve the end. End is more important. So that's why I always say that whenever you draft a petition, don't pray for any particular petition. Why should you invite trouble for yourself? You should keep the petition open-ended. If you are praying, then you say that be pleased to issue appropriate direction, order, or writ to quash and set aside a particular decision, or directing the authority to do this or to forbear doing this thing, etc., etc. Or if you are asking for a writ in the nature of habeas corpus, you can simply say that be pleased to direct so and so person to produce that person before the court. So I always, because when constitutional language, Article 226 does not confine the jurisdiction of the High Court to issue only traditional writs, why should you confine the jurisdiction and invite trouble? Because as soon as I said that you use a particular writ, then you are inviting trouble, because then court will keep on asking query that have you demanded the performance of the statutory duty, whether there is a refusal. In the matter of certiorari, they will say that the civil court or the tribunal should be joined as a party, because the record of the proceeding, the tribunal or court has to be brought before the court, and then it has to be quashed and set aside. So all those technical problems would come. So there are large number of judgments starting from Basappa, TC Basappa versus TN Nagappa, that is reported in AIR 1954, Supreme Court page 440. There, Supreme Court has clarified the scope of Article 226, saying that it is very expansive and the role of the High Court is not confined to traditional writs. It can mold the relief in the circumstances which require molding of such relief. So it is, and we should not confuse our jurisdiction with the traditional writ jurisdiction. That question was given in 1954, but still we are still so bemused by this word writ. We have always writ petition. Word writ petition is not appropriate or accurate description of Article 2. For convenience, you can refer that it's a writ petition. For convenient purpose, you can use that it's a writ jurisdiction. Of course, the short title of Article 226 also says that it is a writ jurisdiction, but the short title will not restrict the wide jurisdiction that is conferred by Article 226. So basically, I would say that it is not a writ jurisdiction, it is a jurisdiction of judicial review. Judicial review to examine the legality and validity of administrative or executive action, to decide the legality and validity of legislative action, that is statutory law. You can always say that particular provision is violative of Article 1419. You can also pray for a constitutional amendment also being violative of basic structure doctrine. And judiciary, judicial orders, whether they are amenable to High Court's jurisdiction under 226. The Supreme Court has recently said in, recently means 2015, in Radhesham versus Chabina, which in my view it is absolutely a wrong decision. But it's a Supreme Court decision of 3 judges bench, where they have said that you cannot claim writ against the subordinate judiciary. So orders of the subordinate court cannot be corrected by filing a petition under Article 226 or writ of certiorari. They will have to be, if you want to challenge, then you take recourse of Article 227. Now interestingly, that judgment has failed to consider the historical aspect. Secondly, one Privy Council judgment in Annie Besant versus Advocate General, which is reported in AIR 1999, Privy Council page 35 or 39. So in that case, the Supreme Privy Council said that this jurisdiction, writ jurisdiction, is very wide. So provisions of revision contained in CPC, of course, takes care of majority of orders that would be passed by the civil court. Similarly, section 435 of the Criminal Procedure Code also provides revisional power in the High Court. But still, apart from this, there may be cases where these special jurisdictions need to be invoked, and the constitutional provision or provision conferring jurisdiction cannot be construed narrowly. And you cannot by implication take away right of issuing certiorari. So that was a judgment in Annie Besant versus Advocate General, which is, as I said, reported in 1999. Similarly, Bombay High Court also in Lady Dinbai Petit versus MS Noran, it is also 1946 BLR, Bombay Law Reports, 455. So there also they have considered that you cannot take away certiorari jurisdiction, because certiorari is meant to control the subordinate courts. Originally, it intended that whenever subordinate courts exceed its jurisdiction or does not follow the law, then in that case the record has to be certified to the High Court for quashing by the Superior Court. So it was meant for correcting certain errors that are committed by the subordinate courts, and that's why High Court is empowered to issue certiorari. Now this judgment said that you cannot issue certiorari to subordinate court. Now how do you reconcile it with the old provisions, this judgment, and this statement of law which has been upheld by Privy Council and large number of judgments, that the certiorari jurisdiction cannot be taken away by implied meanings. So implicitly there has to be specific express word to take away certiorari jurisdiction. And now because of the constitution, even statute cannot take away, because these are constitutional provisions. These are constitutional provisions, therefore if they want to take away certiorari jurisdiction, then they need a constitutional amendment. So how do you, by judicial pronouncement, take away this very vital jurisdiction of the High Court to correct the errors of the subordinate court? Then one interesting aspect is about habeas corpus. As I pointed out, that habeas corpus became statutory remedy under section 491 of CRPC 1898. The issue repeatedly arises whether habeas corpus is maintainable against private person or not. So original provision was there, 491 clearly provided that habeas corpus can be issued to a private person who has confined somebody in illegal confinement or who has restrained somebody from free movement. So there was a specific provision under 491. Now what happened? When new criminal procedure code 1973 was to be enacted, first of all it was referred to the law commission, 5th law commission, to examine the earlier criminal procedure code 1898. They examined and they made various suggestions, and on the basis of the suggestions of the 41st report of the 5th law commission, this 491 was omitted in the new code CRPC. The reason is the law commission said that now there is a specific provision under Article 226 for issuing a writ in the nature of habeas corpus. Therefore, there would be a duplication of powers. So we should not give such powers, or we should not retain such provision in CRPC, and that is how section 491 was omitted, and in new CRPC there is no corresponding provision. So this law commission has taken this in mind, and therefore by necessary corollary it is available against private person who has confined somebody illegally, and that would also be possible to be interpreted in the light of the language, because as I said that petitions, directions, order or writs can be issued to any person. So habeas corpus is permissible to be issued against private person who has been illegally confined. Somebody, state government, if he has also confined somebody illegally, then also habeas corpus can go. So these are the main provisions. Now coming to the aspect that word any of them. So as I said that still there is a misconception among the judges and lawyers that if you pray for mandamus, you cannot pray for any other writ. If you will pray for a direction, you cannot pray for an order. That is absolutely a misconception. You can combine, because the words are very clear. You can pray for a direction, order or writ, or any of them. Any of them word is very clear to mean that you can have one writ, one order, or you can combine them with any other writ. So that will clarify this aspect. Now for the enforcement of the fundamental right. and for any other purpose. So first part is very clear that for enforcement of fundamental right, petition can be filed. But what are the other purposes? Because there is no clarification, there are no clarification in the judgments also. That what are the other purposes? So other purposes would mean that any action of the executive can be challenged on the grounds other than the fundamental rights also. So there are provisions like Article 300 in capital A, which says that no person should be deprived of his property except the procedure established by law. So it is not a fundamental right. Suppose somebody takes away your land without following the due process of law, then you are entitled to invoke Article 300 in capital A. So that would be any other purpose. It is not for enforcement of fundamental right. That would be any other purpose. Sometimes we challenge the validity of subordinate legislation, saying that it travels beyond the parent act. So that is also not an issue pertaining to fundamental right. Followed. When you are saying that parent act is enacted, which empowers certain authorities to frame rules. Now rules have been framed, and the petition says that one of the rule travels beyond certain provisions of the parent act. So if such a challenge is made before the High Court, it does not pertain to fundamental right. So it means that for any other purpose. Then when we talk about executive actions, usually earlier view of the Supreme Court was that when statute is intra-virus, it is not violative of Article 13. So if statute is intra-virus, then executive action or administrative action cannot be challenged on the ground of violation of Article 14, 16, 19, 21. So that was the earlier view. But after Maneka Gandhi's case, AIR 1978, Supreme Court 597, in that case, the Supreme Court said that not necessary. Even if statute is intra-virus, but if the authority has acted in violation of the fundamental right, it has not followed particular procedure, if the certain wrong things have gone in the decision making process, then in that case, it would violate Article 14 because it would result in unequal treatment, because usually you are supposed to follow law. In particular case, you are acting towards the law, therefore it would violate Article 14. So because of Maneka Gandhi's judgment, the principles of administrative law, this nobody is going to teach you or tell you. The principles of administrative law became part of our constitutional scheme. Now what were the principles of administrative law? Administrative decision, when it is challenged, it has to be tested on the principle of Wednesbury unreasonableness. So that was a very famous judgment, Associated Provincial Picture House versus Wednesbury Corporation, that is reported in 1948, Queen's Bench, page 223. So there it has been stated that if you question, because any administrative action, it can be questioned on the ground that either it is illegal or irrational or perverse. So illegality, irrationality and perversity are three grounds on the basis of which executive action can be tested in the court of law. So if it violates, then that executive action is liable to be caught and set aside. So these principles of administrative law were very much present in Indian constitutional scheme, but they were in the form of administrative law. So when after Maneka Gandhi's judgment, they become part of Article 14, and that is how we file every petition under Article 226, whether it actually violates, whether there is a direct violation of fundamental right or not. We entitle every petition under Article 226 and Article 14, 16, 19 and 20, 14, 19 and 21 are always inevitably invoked for the reason that you are raising a plea before the court that particular decision of the authority is perverse, the authority is guided by irrelevant consideration, relevant considerations have not gone into the decision making process, or the decision is without any evidence and perverse. So these are the grounds, and there is a one very judgment, it was Makhan Singh case, probably of 1966. In that case, the question arose that when presidential order under Article 359 was in force, nobody can approach the court for enforcement of fundamental right by invoking Article 14, 1921. So very clear. So you are not entitled to approach the court for enforcement. In that case, the detention order, who was detained under preventive detention law, was questioned on the ground of mala fide, colorable exercise of power, or irrationality, irrelevant grounds, etc., etc. The Supreme Court said that despite there is a prohibition under Article 359, that person cannot approach any court for enforcement of the fundamental right, but these are principles of administrative law, and Article 359 would not prevent the court from examining the legality of detention on the ground, all these grounds, that is witnessable unreasonableness. So there are very important aspects of the Article 226, and now very quickly 227 also, so we can complete the discussion. So please bear it in mind that don't go by the notions which are prevalent in legal fraternity. You will have to apply your mind. You can also question the judgment of the Supreme Court. As I said, the Radhesham Chabinath case is not in accordance with the origin judgment of the in any Besant's case, and most importantly, it has relied upon the judgment in Naresh Sridhar Mirajkar case versus State of Maharashtra, which is not relevant, where the issue was that High Court on original side was trying a suit, and during that suit, a deposition of one particular person was prohibited from being published. And that decision was questioned before the Supreme Court by way of Article 32. And Supreme Court said that High Court, being a court of record and superior court of record, it has all power. So we cannot issue a certiorari to High Court which is examining a particular suit on its own merit. There is no proposition that subordinate orders cannot be examined by High Court. The proposition is different. So that Naresh Mirajkar's case has been wrongly understood and has been wrongly applied in Radhesham versus Chabinath's case. And most important aspect is that this Naresh Sridhar Mirajkar's case refers to Halsbury's Laws of England, 3rd edition, which is published in 1956 or 53, where it was held, or it was stated that superior court cannot issue writ of certiorari to subordinate courts. But that mistake was corrected in the 4th edition, because by that time in 1960 there were 2-3 judgments of the King's Bench where it is held that subordinate courts are also amenable to certiorari jurisdiction. So even if it is a superior court, the High Court is entitled to issue a writ of certiorari to subordinate court. So if you simply go by Radhesham versus Chabinath, then you have to go by what has been laid down. But as a lawyer, it is our job to allow development of law. So something which was never conceived has been said for the first time in 2015. Earlier there was no such law that certiorari cannot go to subordinate court. In fact, on the contrary, it was meant for and the scope was expanded to cover quasi-judicial authority or administrative authority exercising judicial function. Now only 227, and then we will have discussion. 227 is power of superintendence. It is as such not a remedy. It is a duty cast upon the High Court. Power of superintendence means whenever subordinate court exceeds its jurisdiction, then to keep such subordinate courts within the bounds of jurisdiction, power of superintendence can be exercised. So as such, it is not a remedy. And there is a historical background that it was originally Section 15 of the Indian High Court Act, which provided power of superintendence. Then Section 107 of Government of India Act 1915 also provided power of superintendence. But there is a slight departure when 1935 Government of India Act was enacted. In that act, Section 224 was introduced, which confined this power of superintendence to administrative power only. So for the first time, earlier it was considered by judicial interpretation that power of superintendence does not necessarily mean only administrative power to call for the record or call to fix the fees or table of fees or prescribe the formats of suits, etc., etc. So judicial interpretation was that it is not confined to only administrative power, but in a given case, when the High Court finds that subordinate court has violated all norms of propriety, then in that case, as a superintendent, it is the duty of the High Court to correct such things, correct such deviation. So it is a power of superintendence. But then 227 was enacted, which was confined to administrative power under section 224 of the Government of India. That restriction was removed. So now, because of this language of Article 227, it is permissible not only to control subordinate courts administratively, but it also includes judicial control also in a given case. In a given case, judicially also subordinate court decision can be controlled. So Radhesham only says that certiorari is not available, but you can control the jurisdiction or orders passed by the trial court under Article 227 as a superintendent over the subordinate courts. And another thing which was not there in earlier enactments, which are corresponding to Article 227, is that not only courts but tribunals are also brought within the purview of Article 227. So High Court has power of superintendence not only over the subordinate courts but over the tribunals also. So when jurisdictional error is of such a nature that it demands immediate intervention by the High Court, power of superintendence can be exercised. That is my view of looking at it. And Supreme Court has also in first judgment in Vahyam Singh versus Amarnath, which is reported in AIR 1954, Supreme Court page 215. There it has examined the historical aspect of Article 227, and it has said that under Article 227 only jurisdictional error can be corrected, not other error of law or other error of fact, or even error apparent on the face of the record cannot be corrected under Article 227. So my view is that Article 226 is a remedy available to citizen when he is wrong. Article 227 is a duty of the High Court to keep the subordinate courts and tribunals within the bounds of their jurisdiction. So focus is different. In Article 226, the focus is on the violation of the fundamental or any other right of a person. So focus is on that. Whereas under Article 227, the focus is on the duty, whether High Court should intervene or interject in a situation where the trial court or subordinate court has exceeded its jurisdiction or has thrown all norms of propriety to the winds. So that is the width of Article 227. Of course, under Article 227, now the Supreme Court is also considering that even perverse order can be, but that is not the correct interpretation. First interpretation of the Article 227, if you really are interested to understand the interpretation, which was not blurred by any other views, that is in Dalmia Jain Airways versus Sukumar Mukherjee, which is reported in AIR 1953, Calcutta, page 153. So that is which is the main law which has for the first time interpreted after the Constitution came into force, the Article 227. And it has clearly said that only as a superintendent you have a duty to correct only these kinds of errors. And that is how one important aspect about this, that from the order of the court, single judge of the High Court under Article 226, intra-court appeal is provided. But the logic why order of the single judge, when it is passed under Article 227, cannot be challenged in an intra-court appeal is there, because High Court itself is exercised as a superintendent. So there cannot be superintendence over the superintendent. Therefore, intra-court appeal in the High Court is not permissible if the order is passed under Article 227 by a single judge. But if the order is passed by a High Court single judge, on certain civil side, criminal jurisdiction is excluded. So on civil side of jurisdiction, if single judge has passed an order, that can be corrected by way of filing an intra-court appeal. In Gujarat, it is known as letters patent appeal. Now there is high time. Letters patents have gone. Letters patents were issued in 1862, and still we are sticking to the nomenclature of letters patent appeal. The more accurate description should have been intra-court appeal. But nobody is willing to change all these things, and still we are facing this problem of writ. And I must point out one important aspect which has happened in England. Now in England, no more writs are available. They are to be claimed under the single head of judicial review. So in England, there are no writs available after 1981 Senior Courts Act 1981 has abolished all these writs, and I think after 2000, even this Queen's Bench have also gone there. Also, the Supreme Court of England has come. So there, no more traditional writs are invoked or available. They are available in the form of a single remedy of judicial review, and that is the development that has taken place. But we are still debating in Supreme Court and High Court what is the requirement of mandamus, why are you not seeking certiorari, why are you seeking quo warranto, what are the restrictions, why certiorari cannot go to subordinate. Forget it, why do you want certiorari? If you are High Court, if you want to exercise jurisdiction under Article 2, you are entitled, free to entertain this petition over the subordinate court, because it says government. Article 226, if you recollect, that to any person, authority, and in appropriate case, government. So government consists of three wings: legislature, executive, and judiciary. How do you exclude judiciary? How do you interpret this in a narrow manner? Government, word government, and word any government. So it may be central government, it may be state government, it may be local municipality, it may be executive wing, it may be a judicial wing, it may be a parliament, legislature. So all these authorities and government wings are, in my personal view, are subject to the jurisdiction of Article 226. But you have to go by what has been laid down by the Supreme Court, and I wish that someday it will be corrected. Let's hope. So now let us have discussion if any question is there.
If under Article 227, the High Court only has jurisdiction to set aside a subordinate court's order if there was a jurisdictional question.
There are right.
That is a question of law. Sir, what if such jurisdiction itself was tweaked or like mistaken because of a question of mixed
Mixed question of
facts and law, or just facts?
Right.
Because you said it has to strictly interpret in the terms of law only and not
Right.
raise questions.
So that is the law which has been laid down in Variam Singh versus Amarnath. Then in Muhammad Yunus case also 1984, there also it has been said that under Article 227, only jurisdictional error can be corrected, no other errors within the jurisdiction. Suppose I come to a mistaken opinion, I form a different opinion, mistaken opinion, and I give a different judgment on interpretation of particular provision which may be incorrect, but that cannot be corrected under Article 227. That is a correct interpretation of the Supreme Court. But now, in view of that judgment, now every petition will have to come under 227 when it is against the subordinate court. And why only subordinate? Because word tribunal is also used, but that the court is not answering. Because otherwise 227 also now uses tribunal. So if tribunals are gone from certiorari, if the courts are gone from certiorari, so what is the purpose? So that's a interpretation which is a correct interpretation. Whatever interpretations that are contrary to this, Variam Singh versus Amarnath, Muhammad Yunus, Sadhna Lodh, Surya Dev Rai, all these are the judgments which throw light on the width of Article 227. Yes.
In the lecture about Article 226 in PC or Article 32, there are special provisions to avoid or to correct the gross errors or gross violations finding the jurisdiction, will it not be a kind of abuse of process or defeat the purpose itself?
Actually, these provisions, these remedies are meant to correct injustice, instances of injustice and give immediate relief. So on the contrary, Article 226 has to be interpreted in the widest sense to see, and it has been also already been interpreted in Dwarkanath versus Income Tax Commissioner, Kanpur, which is reported in AIR 1966, page 81, where it has been said that the width of the Article 226 is to reach injustice anywhere. So wherever there is injustice, the High Court jurisdiction is there and it can reach injustice and do the justice to the person concerned. So it has to be very wide because the courts, High Court, Superior Courts are sentinel on the qui vive of the fundamental rights. So it has to work as a sentinel that nobody's fundamental rights are violated, nobody is done injustice by the government authorities or individuals. Yes, please.
Sir, I have a similar question that as you said, under Article 26, High Courts have a very wide power.
Right.
So, then such wide, what if in a situation if High Court oversteps its role, isn't that a miscarriage of justice? So,
It's not oversteps.
yes, its role under the said articles, wouldn't that
Okay.
be a miscarriage of justice?
No, therefore, intra-court appeals, see, suppose a single judge exercising jurisdiction under Article 226 and it violates certain provisions of law, its judgment is not in accordance with law, then there is injustice. So the person who is aggrieved by that order is entitled to either approach intra-court appeal. Intra-court appeal is provided for. But if that is not available, then he will have to approach Supreme Court of India by filing special leave petition, or there are certain articles which provide that if certain important constitutional issue is there, if certain important civil issue is there, then by certificate also party can approach the Supreme Court. But usually people file special leave petition, that is under Article 136 against the order of the High Court. So where Supreme Court has unfettered jurisdiction, they don't want to limit their jurisdiction. Repeatedly it has been said that you provide what are the norms for exercising Article 136. But Supreme Court is not willing to lay down its parameters because they want to act whenever they want to interfere, they want to interfere. They don't want to interfere, they don't interfere. Yes, please.
Does the power of High Court in 226 extend to other states as well? Like,
Yes, sir, it's a good question. See, earlier the provision of Article 226 was there that High Court shall have jurisdiction throughout the territory in respect of which it has jurisdiction. So it was limited to the particular state. But in Election Commissioner versus Saka Venkata, AIR 1953, Supreme Court, I think 215, there this issue arose and it was held that High Courts cannot issue directions, order, etc. outside the particular state. That led to a constitutional amendment in 1963, whereby the cause of action, concept of cause of action has been brought in. So irrespective of whether the seat of authority is outside the state or not, but if the cause of action arises in a particular state, then that court will have a jurisdiction. So you will have to satisfy that though particular tribunal is situated outside, like NGT, National Green Tribunal, Western Region, which is situated in Pune, but if it is in respect of any industry situated in state of Gujarat and certain orders are passed, which a party does not propose to go to Supreme Court, and if he wants to take chance before the High Court, it can be brought because cause of action, because notice must have been, notice of closure, etc. must have been issued in state of Gujarat. So one has to satisfy that cause of action partly, or even Supreme Court has gone to the extent that fraction of cause of action, if it has arisen in the territory of a particular state, that High Court will have a jurisdiction. Yes. See, in L. Chandra Kumar's case, if you are aware of it, it was a question of Article 323A and 323B mostly, or 329, I am not sure, 323A and B. which created Central Administrative Tribunal. And the provision of the Central Administrative Tribunal was that whenever the decision of the Central Administrative Tribunal is there, the appeal would lay before the Supreme Court only. The question arose that it would cause tremendous difficulties to the litigant who is in state of Gujarat or maybe in state of Madras or Kerala to approach the Supreme Court by way of filing a statutory appeal. So in L. Chandra Kumar's case, which is reported in AIN 1997, Supreme Court page 1225. In that case, the Supreme Court said that Article 226 and 227 are basic structures, forms the basic structure, and therefore it cannot be taken away. So on a limited ground, whenever decision of Central Administrative Tribunal is to be questioned, it can be brought before the High Court under Article 227 or 226 before a two-judges bench. It should not be dealt with by a single judge. So in L. Chandra Kumar's case, to that extent, the provisions of Article 323 and 323B was partly held to be ultra-vires, violating the basic structure doctrine.
So,
Yes,
diluting a bit from the theme that we had,
Yes.
if you could just guide us to all of us who are interested in this field of litigation, something that we can take into consideration. How do we build about our career in high courts, trial courts, Supreme Court?
Yes. Now, as I said that if you want to practice in High Court, you must have a clarity of, first of all, Article 226 and Article 227, that is most essential. Apart from that, we rarely come across the cases where actual violation of the fundamental right is involved in a litigation. We though say that we are practicing in a constitutional court, but we are actually practicing administrative law, which is considered to be a branch of constitutional law. So, if you want to practice, you must know properly administrative law, what is the impact of violation of principle of natural justice, what is Wednesbury unreasonableness, and then principles of proportionality has also come into, because from original Wednesbury reasonableness to proportionality principle in Om Kumar versus Union of India has also been recognized, and it has been said by the Supreme Court that proportionality is part of our constitutional scheme, because Article 19 says under Article 2 to 6, the state can impose a reasonable restriction. So reasonable restriction means it has to be proportionate, and as soon as we talk about proportionality, it's a proportionality basically, reasonableness means. So one has to have knowledge of administrative law. Plus, if you are practicing in a high court, you are on civil side and criminal side, you will be handling appellate jurisdiction. You are handling cases of appellate jurisdiction or revisional jurisdiction. So for that, concept of appeal revision should be clear to you on civil side also. Civil side, first appeal, then certain orders are appealable under order 43, so appeal from order. Then revision is available against certain orders, that is section 115. Then review of the order 114. So all second appeal section 100. So all these things are necessary. If you are proposed to practice on criminal side, you should know about the bail jurisdiction. What are the fundamentals of bail jurisdiction? So you should have clarity of old section 437, 438, anticipatory bail, 439. Then quashing, because right now it is very frequently invoked power of High Court under section 482 earlier. Now it is 522 under the BNSS for quashing FIR or investigation if it is abuse of process of law. So there has to be complete clarity, and you should see it's a very litigation field and non-litigation field. There are two major fields. It is your choice what kind of field